we can embark on a survey of the Indian Copyright Act. Now, the major questions to be addressed are, apart from the nature of the remedies, who can initiate these proceedings? Against who can such proceedings be initiated? Where can you initiate these proceedings? These are all procedural matters, but of great significance to the way in which IP is enforced on the ground, and great significance to the signaling effect in terms of what we as a society send out as a message to those who choose to violate IP. Any discussion of the provisions in Indian law, in the Indian Copyright Act, dealing with remedies has to inevitably start with Section 55. 55 outlines the civil remedies for infringement of copyright and reads as follows. Where copyright in any work has been infringed, the owner of the copyright shall, except as otherwise provided by this Act, be entitled to all such remedies by way of injunction, damages, accounts, and otherwise, as are or may be conferred by law for the infringement of a right. Provided that if the defendant proves that at the date of the infringement he was not aware and had no reasonable ground for believing that copyright subsisted in the work, the plaintiff shall not be entitled to any remedy other than an injunction in respect of the infringement and a decree for the whole or part of the profits made by the defendant by the sale of the infringing copies, as the court may in the circumstances deem reasonable. So, subsection 1 of section 55 clearly provides for all the different remedies that we have discussed thus far, such as injunction, damages, accounts, and so on, and also contains the same principle that we had seen in the TRIPS agreement, wherein a defendant is not liable for payment of damages unless he was of the belief reasonably, or would or ought to have had the reasonable belief that copyright subsisted in the work which he is now alleged to be infringing. Apart from section 55, there is an important aspect of the right to sue which one may keep in mind, which is that there is no presumption of ownership except where one has obtained a registration of copyright. So the fact that you have registered your copyright, while not determinative of you enjoying the right, because copyright protection, unlike patent protection, is not dependent on the fact of registration. Yet, the fact that it is registered offers you a presumption of ownership when you sue the defendant. Of course, it is for the defendant to rebut the presumption, but on the face of the record, because you are mentioned as the owner in the register maintained by the Registrar of Copyright, you are presumed to be the owner unless proven otherwise. So once we have this sense of the landscape in terms of the remedies and the presumption of ownership, it is best to quickly look into the different categories of people who can sue in respect of infringement of copyright. So the first important category is, of course, the owner. Now normally, because of section 17 and the presumption that authors are the first owners of copyright unless as otherwise provided in that provision, authors in their capacity as first owners, joint owners of copyright, again a situation where both parties collaborate with the intention that they shall both jointly own the copyright in respect of that work. Then producers or employers who become first owners, valid assignees of copyright, that is those who take the copyright from the initial owner or subsequent owners based on a on an assignment deed, which is a deed for the transfer of the copyright. Exclusive licensees and copyright societies. Now, exclusive and non-exclusive licenses are just two categories of licenses. So, non-exclusive license is where any party other than the present licensee can also be granted a license by the licensor. So, there is no bar on the licensor from granting multiple licenses. But an exclusive license is one where, at least in respect of that particular exploitation of copyright, the right shall exclusively vest with the specific licensee, and there is a bar on the licensor from granting a license in respect of that particular use of copyright or the copyrighted material to any other licensee. So, in respect of a film, for instance, one party may be given an exclusive license to remake the film in language X, another in language Y, and a third in language Z. Normally, where there are exclusive licensees, the exclusive licensee can sue, but the law requires the copyright owner to be impleaded as a defendant. One of the reasons for this is that there is a statutory bar on the copyright owner under section 61(2) from instituting any fresh suit or proceeding in respect of the same cause of action. So, because there is such a bar, it is only fair that the copyright owner is heard in the other suit which is instituted by the exclusive licensee. As far as copyright societies go, interestingly, the Act is vague about their right to sue. But in a decision of the Delhi High Court in Phonographic Performance Limited versus Hotel Gold Regency, the division bench has held that a copyright society can initiate a suit for infringement, and that too without complying with the provision for impleading the copyright owner. So this is a very interesting sort of verdict where the court has really looked into the purpose behind creating a copyright society in the first place. Now, copyright societies are nothing but societies which have been created for the collective administration of rights of various copyright owners of different classes of works. So, the copyright society would be representing a class of works, like for instance in the case of sound recordings, the Phonographic Performance Limited is the copyright society under the Copyright Act, and which in turn administers the copyrights of sound recording labels which are members of the society. So what the law says pursuant to Phonographic Performance versus Hotel Gold Regency is that if you are a copyright society, you don't need to implead the owners of copyright as part of the suit, and you can independently file a suit against the defendant, and you can claim damages and you can get an injunction and so on and so forth. So these are the different categories of actors who can sue for infringement of copyright, and the various nuances, at least some of the important nuances which the action entails. Similarly, an interesting issue is who can be sued. Now here the most important category of those who can be sued, which needs or merits discussion, is the prospect of suing unknown infringers. Now today we have come to a stage where the moment a film is released in 2 or 3 days, or sometimes even earlier, copies of the film, and reasonably watchable copies one could say, are available on different BitTorrent sites or sites that make use of the BitTorrent software, and easily people can download it, watch it, as a result of which there is little interest in venturing out of home to a movie hall and watching the movie. And the same is the case with books. There's a lot of content. That online piracy is at an it's today capable of really impacting considerably the revenues of the uh, physical channels of distribution, the authorized channels, so to say. So then the automatic question is, when there are many of these individuals who are committing infringement, whether it's online or even cases of trademark counterfeit goods, for instance, or in copyright, pirated copies, hard copies of the book being sold by different vendors outside a railway station. So in all these cases, the real challenge is enforcing your IPR. Can you sue each of these infringers independently? Is it even practically viable? The answer is of course not. It's not. It's not possible, especially in the case of online piracy, even otherwise. So one of the interesting remedies that has come about, and the history of that is traced in the course material, so you can go through that. Right from the day of Billy Joel versus various John Does to the present day, where the court is also seriously contemplating or has already performed the laying down of checks and balances of the passing of such orders as well, because sometimes they can take an excessively harsh and unbridled tone and tenor. So from then to now, there have been instances, and these serve as precedents today for us, where the court allows the plaintiff to file the suit against known and unknown infringers, and the unknown infringers are in turn listed as the various John Does. So this has come to be known as the John Doe Orders in IP. So the purpose of these John Doe Orders is to bring to the table those unknown infringers. And how does the law seek to do that? It does so by way of the grant of an interim order already against these guys, and when they are detected or found infringing, the interim order is immediately served on them. So the prohibition applies from the moment they are found, the moment they are caught. There is an interim order served and there is a prohibition on them. So if they were to sell it from that very moment, they would be liable for contempt of court. So this is the way the law is enforced, by making them liable for contempt of court the moment the act of infringement is carried on and they are discovered in the process of doing so, and by virtue of an order of injunction which is already present against all unknown infringers. Now what do they do? What is the solution for them to get over this predicament? Well, if they feel that they are licensed, or they feel as is justified in doing what they are doing, whatever may be the reason for that, then of course they can approach the court of law and they can seek to vacate this order of injunction which has been passed against them. Of course, it's a different matter that most people will not do so, because many of these are not anything but eyes open infringement cases. So there is no possibility of any justification for that conduct, legally speaking. So it is a pretty interesting mechanism, as long as it is not abused to the extent where people go search, seize equipment and so on and harass others while in their business. John Doe orders can be pretty effective in enforcing copyright. Today, of course, we have come to a situation where John Doe orders are largely used in the case of online piracy. With several films recently, John Doe orders have been used, and pretty effectively, for the reason that the Department of Telecommunications and the different internet service providers are the ones impleaded as the known parties in the proceeding. So the idea is in some sense to enforce the order against these unknown online pirates by resort to the mechanism of the ISPs and the DOT. It seems to have some effect and is in any case a fairly practical way of implementing and enforcing the law.